Hello and welcome to the fourth in Stephenson Harwood's webinar series on M&A in times of disruption. Those of you who've joined us already will have seen our sessions on the industry outlook for 2022, the rise in regulatory hurdles, and heightened COVID M&A risks. Next week, we also have a seminar on distressed M&A, so please put that in your diaries. Today, we're going to be focusing in on avoiding other M&A risks and liabilities, particularly in the areas of litigation, tax, IP, and financial regulatory. Before we get started, some brief housekeeping. Today's webinar is being recorded. And there is also a question and answer functionality at the end for those of you familiar with Zoom, which I'm sure is pretty much all of you by now. If you just click on the Q&A section at the bottom, put in your question, and we will look to set some time apart at the end to deal with any questions you may have. I'm joined today by Genevieve Quirine, Commercial Litigation Partner in our London office, Justin McClelland, a Financial Regulatory Partner in our London office, Kate Worthington, a Tax Partner in our London office, and Joshua Cunnington, a rising star in our Intellectual Property team in London. My name's Sandeep Dharma. I'm a M&A Partner in the Stephenson Harwood Dubai office. Without further ado, let's get started. Genevieve, I thought I might come to you first. What disputes do you see arising most frequently in the M&A context? And do you think there are some deals that are more prone to disputes than others?
I mean, there are obviously a very large number of different types of disputes that arise in the context of M&A deals. They are significant events in the lives of all of the parties to those transactions, including the counterparties, but also shareholders, directors, employees, creditors, customers, suppliers, sometimes even governments or regulatory bodies. You know, you can get quite a wide variety of different types of contentious situations that arise. Generally speaking, M&A disputes tend to fall into two different categories. There are those that arise between the counterparties to a transaction, and those arising typically between a stakeholder and a party to the transaction. So, for example, the target company's shareholders or directors are in dispute with the target company. Over the past couple of years, I've advised clients in both categories. I don't think I've really seen a pattern that suggests some deals are more prone to disputes than others, as the disputes I'm called in to assist with arise in a variety of sectors and as a result of the specific circumstances of the deal in question. So they normally involve mismatched expectations, poor communication, ulterior motives of some of the parties, and so that it's very much dictated by the particular characteristics of the transaction in question. What I would say, though, is that generally speaking, the contentious situations arise either because deals haven't been adequately papered up, or the documentation is overly complex, and it tends therefore to be more prone to disputes, as reliance can be placed by both parties on alternative constructions of a poorly drafted clause open to multiple interpretations. So, generally speaking, courts assume that parties to an M&A transaction have fully negotiated the documents and are sophisticated parties, so they are generally held to the bargain they've agreed. So I would say, I guess, the big learning point for parties to a transaction there is to make sure that all of the documents are as clear as possible in relation to what they are trying to achieve from the transaction. Just to give you a very brief overview of some of the disputes I've advised on in the past year in the M&A context, they've included a third round of private equity investment, where the investing consortium wanted to have a presence on the board, and the majority sought to use the investment not only to remove minority shareholder clients' representative directors from the board, but also to dilute my clients' shareholdings and reduce their powers. That was resolved. generally speaking, these disputes do tend to be resolved before going to court. Certainly I deal with, which I think is probably a good thing. A post-completion breach of warranty claim for misstatements in the completion accounts, where I represented the defendant sellers. And most interestingly, I think, a very rare claim made in reliance on a material adverse change clause in an SPA, following the alleged reduction in value of the target between signing and completion due to COVID. Okay. And I was advising a stakeholder on the likely outcome of that litigation.
I mean, if I could drill down on that one in particular, obviously, as an M&A lawyer myself, MAP clauses, particularly in the last few years, have been a real hot button issue. In terms, is there a test, or is it very much reliant on what the parties should be agreeing would constitute a material adverse change, or the court seek to apply its own parameters around that?
Yeah, well, I mean, generally speaking, normal rules of construction apply. So the court will, generally speaking, rely. It's the burden of proof on the seller in relation to demonstrating that the clause that it's relying on it should be interpreted in the way that it's arguing. In the case that I was acting in, the court basically held the parties to the common sense interpretation of the clause in question. There were two separate areas they were looking at. One was to do with the industries in which the target operated. The target was trying to argue a very limited definition of the industry in which it operated, and the acquirer was arguing much broader, and the court found in favour of the acquirer in that particular argument. But then there was also a question as to which carve-out clauses could be relied on. And what the court found there was that if you've got two clauses which potentially conflict with each other, and one could be rendered completely pointless by reliance on the other being permitted, then you can't, that interpretation isn't open to you. So it has to have, that the interpretation has to have a logical and natural practical outcome for the parties. And the conclusion was that the parties to that deal, which was a very, very valuable deal, over $1 billion, must have engaged in a significant amount of negotiation of that clause.
Yes.
And therefore, you couldn't argue that there were other sort of less obvious interpretations that should be relied upon.
Okay, that's interesting. I mean, we've had something very similar here, not on a MAP clause, but whereby reliance on one clause with a very broad construction would have driven a coach and horses through a massive LPA agreement. And as a result, an arbitrator we were speaking to just said that that's ridiculous. You can't sit, that simply wouldn't make sense.
That's exactly right. If it results in a consequence that is just pure, outrageous or impractical, or something that the parties could not possibly have had in their contemplation when they were negotiating that clause, then the court is likely to find against that interpretation.
Excellent. Well, I mean, one of the things you did say was that you haven't necessarily seen a trend in terms of sectors. Joshua, if I could just come to you for a second. Would you say that's the same from the IP intellectual property side? Or have you seen any particular sectors or types of deals which have been particularly prone to disputes?
That's a great question. One of the key sectors that we are seeing issues recurring in is I guess it's the energy sector, in particular renewables, where there is a significant amount of development going on, which needs to be protected through IP rights. But in addition to that, I think probably the second biggest area that we're seeing issues arise is in relation to software and data-driven businesses. And I'll discuss the two issues briefly that kind of touch on both. I'll come on to them, but it's important to note at the beginning that when I talk about software and data, I'm not just talking about kind of the large technology players. You know, bespoke software, whether it's an entire program that's been developed for a company or some kind of business critical module that sits on top of off-the-shelf software, we're seeing it becoming increasingly pervasive throughout all the deals that we're doing. You know, software and data is no longer just a kind of a niche consideration for clients, and particularly, you know, for buyers when they are entering into deals. And in short, software and data needs to be considered as a potential risk at the outset of pretty much every deal. And so the main real problems that we're seeing, or really kind of the source of these issues, is that there are insufficient processes that have been put in place at a target business throughout its life cycle. And that's, you know, natural. You know, often these, you know, businesses, as they grow, they start off quite small. They're quite, you know, small entities and closely held. But as they grow and they can become obviously very, very large, the processes don't often keep up. And there's often also a lack of documentation, particularly where there's been a history of acquisitions. And what this means is that when you end up doing due diligence on these targets, you often find that there are skeletons hidden multiple layers down in the acquisition chain. So, for example, if there's been a subsidiary set of companies built up over time, a group, and this all boils down to the value of the deal, because at the end of the day, particularly in the two areas that I've just referred to, IP can be absolutely key to the value.
Absolutely.
This is not just you shouldn't just give it lip service, I think.
No.
So just touching on the kind of what we really mean then by the risks. There are three core ones from what we're seeing, you know, as trends. The first is ownership, and this is an issue throughout every deal when it comes to intellectual property, and every business uses contractors and consultants, and particularly this is particularly an issue for software, because often there are developments which are made, bespoke software which is put together for a business, but that's not done in-house. And what we often find is that there is a lack of documentation put in place between the developer and the target business. And the starting position in law is that, subject to any terms to the contrary, this is under English law, the company that is appointing that developer or the contractor will not own the resulting IP, and it will be held and owned by the developer. Now, this can be solved, patched up later on when it comes to an acquisition through assignments, but often it can lead to the contractor developer coming back for more, and you often won't have a strong negotiating position. And really, if this software is important to the business, and we are, as I say, we're seeing it more and more so, where the businesses are relying on this software for their operations, it is incredibly important that the correct ownership position is dealt with and is set out properly. And obviously a key risk is that fundamentally, if you don't own this software and you don't have a right to use it, and often there might be an implied license to use it if someone's developed it for you, ultimately the developer can come back to you, cause issues for you, claim that you're infringing perhaps, and trying to seek a favorable deal for themselves. Equally, there are greater risks. For example, if you simply don't own it, there can be infringement risk as well, which is much more serious. A second issue that we're seeing from the data side of things, and I'm actually working on a deal at the moment that is, and we've seen a few more of them in the past year or so, is that data-driven businesses are becoming so important. What that often means is that there are multiple in-licensed sources of data that these businesses are using. So they're not data sets which are being created organically. They are third-party sources which are being used. And what a really common problem we're seeing is that basically the use that is being made of these data does not conform with the terms of the license which has been taken, and that ultimately constitutes a breach of the license, and potentially, well, copyright infringement is a key risk. And this is a litigation-heavy industry in data, and therefore it's a real practical risk rather than just a theoretical one. And just to touch on
I suppose, if I may, I mean, we started off by talking about sectors, but there isn't a data sector in that respect anymore, because it's everywhere. It's in every business, regardless of what.
This is right, and it pervades throughout all sectors, really. So it's fundamentally important to pretty much the majority of businesses nowadays, across a lot of different all sectors, really. And that's exactly right. Just to touch on a particular sector, though, I touched at the beginning on renewables and green tech. Now, that's something that we're doing a lot of as a firm, and something that we've seen crop up from an IP perspective in transactions. And really, one of a key challenge here goes to often the validity of patents. Now, there's been a period of time when actually patents in businesses haven't been particularly relevant, apart from in kind of high tech engineering businesses, for example. Or they tend to play a bit part often. And what we're seeing more and more in the energy deals is that in order to secure and monetize those inventions properly, patents are fundamentally important, particularly where they are single product businesses. And it's important to remember that these patents can effectively provide you with a legal way of blocking competition from the market. And stopping competitors from using your technology and invention. And therefore, if a business does have a patent, and it does have patentable inventions, then it's fundamentally important that they're protected, and the DD is done to make sure that they have been protected properly. And a big risk that we've seen is that these, often where you've got startup businesses which have then grown and been acquired, because there's a huge amount of consolidation going on in the industry, is that inadequate controls have been put in place in the target, and there's been a lack of documentation, which leads to risks in relation to invalidating patents through prior disclosure, which means kind of making them available to the public, which can be inadvertent. And also going back to what we were talking about, ownership. So, for example, you might find that the inventors are still owning these patents when actually they need to be in the name of the target. So I guess those are the kind of the few things that we're seeing at the moment crop up on a regular basis. I guess the question is, what can you do about them? And it all comes down to, fundamentally, at the very beginning of deal, understanding where the valuable IP sits, and then being able to hone in on that and focus on it as part of the DD exercise. Which then leads on to the second issue, which is making sure that the due diligence is done fully and that enough time is allowed for in the process, particularly where there is believed to be very important, valuable intellectual property. Because at the end of the day, if it's not done properly at the start, it's very, very difficult, if not impossible, to then go back and unpick it later on, at least without incurring significant costs. So yeah, from a buyer's perspective, so the kind of key things to think about. The same goes to the seller. If you want a very quick and nicely run deal, I think conducting some vendor DD is a good idea often, particularly if you're slightly concerned that the house isn't fully in order, and then that will effectively enable the deal to be run a lot more smoothly and cost efficiently later on.
Understood. Okay, that's a lot to think about from the IP point of view. Kate, if I could just throw this over to you. Obviously, tax, as an M&A lawyer, almost every deal is driven by tax considerations. How do you think a seller might best prepare to mitigate any issues that that they know are coming up when they're coming up to an M&A event?
Yeah, well, obviously the starting point is that in M&A deals, sellers typically take all the pre-completion tax risk, and they either stand behind that via a tax deed or tax indemnity, or there's a tax indemnity which insurance stands behind. So a big part of deal preparation on the sell side, as you say, is to identify existing tax risks, and much as Joshua was saying, get your house in order and make sure that you have identified the tax risks, and make sure that you, one, have a filing position. And by that you mean most tax, especially in the UK, is self-assessment. So if you think you've got a tax liability, you have to self-assess it to the tax authority. And so by saying we have a filing position, we mean we're happy that we've self-assessed the right amount of tax. That doesn't mean there's no tax risk attached to that filing position. It just means that I don't have to self-report that tax. So that's the first step. And then if there is some tax risk, sellers would be well advised to make sure that they have robust technical advice supporting that tax position that they've taken. And in some circumstances, a clearance from a tax authority saying that the tax authority agrees with the position that has been taken. And buyers will often focus on things like disposals and acquisitions and reorganizations within the group. So it's very important to, first of all, take advice on the tax structuring side before you implement any of those sorts of transactions, and make sure that all the tax risks involved in those have been covered off. And then I guess if there are any tax risks that have been identified, a seller would probably want to make sure that they know what the potential quantum of the tax is, both on a sort of reasonable basis and on a highest maximum basis, so that if they do end up having to negotiate with the buyer on price, because obviously tax liabilities effectively go to price because they reduce the value of the business potentially, the sellers make sure they have all the relevant information so that they can negotiate with buyers on a proper basis, because obviously buyers are motivated to try and get as much off the price as they possibly can, and a seller will want to say, well, I've taken this advice and actually the more reasonable position would be this, and let's meet in the middle, or whatever the negotiating position is. So a seller will then know what options they have to take it forward.
Okay, excellent. Okay, well, just I think to move our discussion forward, you know, obviously in the last few years, as an M&A lawyer, my clients, when they're doing deals, like certainty, they like stability, they like visibility, and the last few years have not been ideal in that in that respect. We've had perhaps 3 black swan events, I guess, in the last few years, being, you know, Brexit in the UK and Europe, obviously the pandemic, and the current situation in Ukraine. And I think following on from discussion we've already had, I think it'd be useful to turn to the effect these have had on the contentious situation that do arise out of M&A transactions. Now, I can say from my point of view, as an M&A lawyer, I've been telling my clients that we need to really drill down and do some robust DD on supply chains. For example, how robust are they? Are there alternative suppliers? Are there logistical issues? Are there geographical exposures that could affect those, and what will they do to cash flow? Is there disaster recovery planning? And then, you know, once they've got some sort of visibility to the extent they can on those, considering how the deal is structured, whether there are deferred consideration elements, what those might, and if you do have those elements, how those might be taxed in the future. In the past, we were seeing a trend towards lockbox style deals, but I think as these issues have come up in the last few years, we've gone back towards completion accounts based adjustment trends. So I mean, from a sort of deal structuring point of view, I'd say those are issues that we've seen, but I think at the sort of other end, Genevieve, from a general litigation perspective, would you say you've seen other issues brought up by any of these events?
Yeah, so I mean, litigation obviously covers not only being a litigation lawyer covers not only going into court, but dealing with pre-action disputes. As I said earlier, generally speaking, the disputes that I advise in relation to in the M&A world don't end up in court. And I think it's fair to say that there have only really been a handful of cases that have ended up in court where the disputes have arisen in part or in whole as a result of any of those three black swan events. But that's not to say that there haven't been contentious situations that I've seen and that other people have seen and that I've heard about. Obviously, the claim that I mentioned to you earlier that did end up in court arising from the material adverse change clause was an unusual outlier and was very interesting in the guidance it gave to everyone on how to interpret MAC clauses. I also assisted a seller with a similar post-signing pre-completion dispute as a result of the alleged diminution in value of the target company as a result of COVID. I imagine that kind of situation has arisen quite a lot. We avoided ending up in court. The deal went ahead, but at a modestly reduced value. And I suspect that those types of traditional M&A disputes over purchase price adjustments, warranties, indemnities will continue to arise as a result of the pandemic for a little while. I mean, we're not out of the woods yet. I was just texting my husband earlier today about whether my daughter has COVID or not. Thankfully, she doesn't. But you know, it's everywhere at the moment. So there may also be risks for companies arising from the COVID pandemic, where companies benefited from government funding or because of impacts on relations with customers and suppliers. As far as Brexit is concerned, I haven't personally advised any of my clients in relation to contentious situations arising in the M&A field as a result of Brexit, or indeed the Ukraine war. More generally, Brexit doesn't appear to have had a significant impact in the sphere of M&A deals. Most deals involve a conscious choice by the parties as to how disputes should be resolved, including jurisdiction governing law clauses. In finance litigation, where asymmetric clauses are sometimes favoured, there has been a concern about the risk in enforcing judgments where proceedings were commenced under an asymmetric or non-exclusive jurisdiction clause, as they may not be so easily enforceable, given that the Hague Choice of Court Convention doesn't apply. There's no real case law on it yet, but concerns have led to changes in the LMA standard clauses and ISDA bringing out master agreements under French law. And there are obviously procedural inconveniences as service out of the jurisdiction now needs to be effected under the common law, meaning that litigation can be more cumbersome. But I haven't seen deals, basically involving a conscious choice of other laws than English law. I think English law is still very much favoured. As far as Ukraine's concerned, again, I haven't encountered any contentious situations myself. The firm recently produced an article on a shipping case, which is called MUR, Shipping BV and RTI Limited. We can send that to anyone who's watching this, if they'd like it. In that case, the court confirmed a contracting party's right to invoke force majeure where the parent company of its counterparty is subject to sanctions, and clarified that reasonable endeavours to mitigate force majeure doesn't include accepting payment in another currency than that stipulated by the contract. And generally speaking, parties to M&A transactions are experiencing concerns around litigation liabilities for the imposition of sanctions generally, unsurprisingly. Contracts are being amended to make more specific sanctions provisions. And it's also quite likely attempts made to avoid sanctions by putting assets into the hands of trustees may generate litigation, like the Abramovich case, where he was unsuccessful with Chelsea Football Club.
Indeed. Kate, if I can just bring you in very quickly on something Genevieve mentioned about the pandemic and I think some of the sort of government schemes and furlough and the tax, how have those affected the tax position? Or have there been any knock-on effects that you could talk us through?
Yeah, so in the UK especially, there were various schemes for deferral of tax liabilities to help businesses with their cash flow. So buyers have been concerned to make sure that those deferrals were validly utilised and that the tax liabilities have actually been discharged. So that's a reasonably minor element of it. A bigger element of it has been the use of furlough. So, I mean, although this is really an employment issue, obviously has knock-on tax consequences. And also in the UK, the furlough scheme was administered by the UK Tax Authority, HMRC. And buyers have been very concerned to make sure that furlough has been validly claimed and all the procedural aspects relating to furlough were complied with. And for targets and sellers, that's actually been really quite difficult to make out because of the way that furlough developed. It was developed over a short period of time. It was very unclear what the rules were as it was going on, and so it's difficult for targets and sellers to say that we've definitely complied with this. So I've seen situations where buyers have demanded a sort of escrow type arrangement where a maximum liability for potentially wrongly claimed furlough was demanded by the buyer, and then a sort of furlough review was undertaken by a accountancy firm post-completion to assess what the actual risk was. And then the escrow was released when that review had come back sort of clean enough. So that is something to think about, and making sure that buyers have, sellers and targets have all the relevant records to say that they've claimed furlough properly and they haven't overclaimed it, and they told their employees the right information, etc.
All right. Something to bear in mind. Justin, I'm very aware that we haven't heard from you yet. I mean, presumably these sort of events and the sort of supply chain issues that I touched on earlier have put businesses under great strain as they try to struggle to manage stakeholder and shareholder expectation. Have those had any sort of knock-on effects in your field?
Yes, so we're seeing a lot of change as a result of COVID and Brexit, less so in relation to Ukraine, but some of the points I'll come on to discuss are relevant to the Ukrainian situation as well. We ultimately are talking about uncertainty, as you said, as you introduced this section. And when you see any dislocation from normality, that creates risks in my area, which is the regulatory and investigation space. I'm a former prosecutor, so I see it through the lens of criminality often. And the problems that are created in situations like COVID and Brexit and also Ukraine are the challenges of meeting sales targets and profit projections, which might have been produced prior to such events taking place, but still the pressure to meet them exists. You have supply chains, which you've spoken about already, Sandeep, which can be stressed. There might be surges in demand in some areas and some sectors, and drop-offs in demand in other sectors. The use of third parties may change as some go bust, some become irrelevant, some become overloaded, and you then have to bring other third parties into the supply chain as well. There can be an increase in government touch points, which a number of people have spoken about already as well. And set against that background is the fact that a lot of the controls that would ordinarily exist in normal times, if the concept of normality is easily definable now, but what the controls that would exist in normal times are often more lax and they're less rigorous. You have a lot of people working from home where the application of the more orthodox controls and compliance processes might be more challenging. So that's the factual situation, and the legal challenges it gives rise to, I'll deal with under a number of different headings. Firstly is the anti-bribery and corruption. We're talking in the UK context here about the Bribery Act 2010. I've talked about the supply chains being stressed. That would be a continuing problem with import and export challenges that sit around Brexit in particular, but also in some sectors in relation to COVID. You've got the desire to get things through on a more speedy basis. You've got the scarcity of materials and the scarcity of sources. and the increase in the use of third parties, all of that combines to create risks. Third parties are a classic risk in anti-bribery and corruption. Under the Bribery Act, you have a strict liability for the actions of third parties on your behalf. And if you're not able to due diligence them or to test them appropriately, then that creates problems. Set against that as well are the lax controls, which I've spoken about, and an inability to monitor people in the way that you would normally do so. So that's the anti-bribery and corruption type risks. You've also got the modern slavery risks as well. There's an expectation now or requirement that you will produce a report, a modern slavery statement on an annual basis if you meet certain criteria. When you look at stressed supply chains, which arise in this scenario that we're contemplating, then the existence of modern slavery in those supply chains might not be uppermost in people's minds. Uppermost might be getting hold of the supplies in the first place. So when you look at the Modern Slavery Act type risks, we're talking about the PR implications, and these are things that buyers would obviously be interested in looking at in relation to potential targets. Yeah. Also shareholder activism as well. We've got market abuse as another concern. We're talking here about listed entities, but in the time of economic stress, the management of inside information, price-sensitive information, may be less rigorous than it normally is. You've got people working from home. The normal application of insider lists, permanent and ad hoc, might be less rigorously applied. You've also got the nature of price-sensitive information. One thing that we found in the context of the COVID era, if indeed we're out of it yet, as Jen said with her daughter. So the problem with the COVID era was that the nature of price-sensitive information tended to change. Everything had a potentially price-sensitive impact. And so managing that created problems as well. And the risks that an organisation carries in that context is investigation by the Financial Conduct Authority. They are becoming more rigorous in their investigation and surveillance of market conduct, and also breaches of obligations as a listed entity potentially. And then Kate has also mentioned in the tax context about the taxation risks. And here, from my regulatory perspective, I would be looking at the Criminal Finances Act of 2017. That creates strict liability offences where somebody has engaged in tax evasion, and again, third parties, similar to the Bribery Act, can give rise to that strict liability obligation as well. You're looking at furlough fraud. You're looking at people misrepresenting their financial performance in order to, in some way, persuade the market that they're healthier than they are, and that will inevitably have a knock-on in terms of the tax that they pay. So there are a number of issues around the dislocation of the situation that COVID and Brexit and Ukraine would give rise to, which I'd be concerned about from a regulatory perspective. There's one that underlines all of this or underpins the whole thing, and that is fraud generally. And people are seeing an increasing emergence of fraud as a result of events in the COVID era. It's starting to emerge now as people come back to the office, as the orthodox controls are now reimposed, and people are therefore becoming more alive to what was happening, which they might not have been as aware of in the COVID times. But that is something obviously to be alive to as well. And all of that is inevitably measured by the regulators. And here we have principally, in terms of the matters I've discussed so far, we have the Serious Fraud Office in the UK. It is facing its own challenges on a number of fronts, as people who are in the UK will know by just reading the press. That notwithstanding, the deferred prosecution agreements is an area where they have had some success. And there have been a number of cases which have given rise to DPAs where the acquisition of companies where there are problems has created issues for the buying entity. And that really underlines, in bribery and corruption contexts, the need to do due diligence in an effective and comprehensive way. So let me pause there, Sandeep, and I'll come back to the mitigation of risks in due course.
Well, absolutely, yeah. And Joshua, has sort of the IP realm been able to continue regardless of all of these events, or have you seen a sort of knock-on in your area as well?
It's actually quite positive news from the IP perspective. It's fairly business as usual. Well, speaking about Brexit anyway, it's business as usual. Effectively, I think the biggest IP rights which were affected, or the main ones which were affected by Brexit, were probably the registered rights, so trademarks, registered community designs, and also the unregistered community design. They were effectively matched, as it were, with equivalent rights in the UK as of the 30th of December 2020. And so there was no action to be taken for rights holders and therefore target businesses or in relation to their registered rights. And often we'd be talking about trademarks in this context. And so they were not necessarily affected. If you had an EU registered trademark before Brexit, you automatically were granted an equivalent UK trademark after Brexit, and you were able to keep your EU trademark ongoing. Patents are not affected; they're not dealt with under the same regime, and so they will continue regardless. So yes, I mean, from a Brexit perspective, actually, it's fairly positive news regarding IP and risks in a transaction. And in relation to the other points, we're not really seen them. COVID or Ukraine affecting IP generally or at all. I mean, obviously, something to be aware of in Russia at the moment is that there's been a disapplication of IP rights relating to a lot of Western businesses, which are deemed to be unfriendly to Russia. Although to the extent it really has a knock-on effect in wider transactions, it is questionable, particularly given the sanctions regimes in place at the moment.
Of course. Okay. Well, I think in the last 15 minutes, I thought it might be helpful if we identified some of the particular trends we've seen in the last few years. And one thing I think, Justin, that you mentioned quite a lot was about the fact that people were working from home had meant that the risks had been very different. And how would one go about managing some of those risks?
Come off mute. Yeah. So let me start by dealing with the nature of the due diligence risk. Ultimately, as we all know, you can't manage a risk unless you know about it, and that's what the due diligence process is all about. And Josh has already touched upon it in the IP context about starting due diligence early. And there's a lot of areas where often you see due diligence has been addressed later on by the buyer when it needs to have been dealt with earlier because of the long tail issues that it gives rise to. And Kate's already spoken as well in the tax context about the post-completion furlough review that took place. Ideally, we would all get that done as early as possible. So I think if I've got one comment in relation to due diligence, it's to do it early because early engagement is key. I think there's also, in my experience, a resistance to the floorboards up type approach to due diligence where everything is looked at. There's always a risk sensitivity that's applied to these things. And there's a number of areas that I think I could suggest that people could look at in order to calibrate your risk sensitivity in determining what you might want to look at from a due diligence perspective. The first one is jurisdictions. Depending on the nature of the business, its sector and its geographical spread, there will inevitably be some jurisdictions where there are greater problems from an anti-bribery, modern slavery, a taxation perspective. So understanding those jurisdictions will obviously be key. The existence of policies is often something which gives you a sense of the type of organization you're dealing with. Do they have policies on anti-bribery and corruption, on market abuse in existence? Is there an anti-money laundering policy of sorts? If so, are they applied? And how do you identify that? Have they been updated in some way? When was the last time? What is the date of the policy? Has it got a date on it? What version is it? Has there been any training on it? Is there a statement on modern slavery on the website as they're required? If they're required to do that, then they meet the relevant thresholds. In relation to the Criminal Finances Act, is there training in relation to what tax evasion might look like in order to identify whether those risks exist? The existence or not of those policies will give you a flavour as to whether this is a risky business or not. And then sitting behind those...
Sorry, if I could just, I mean, from a if you can demonstrate that, presumably regular training, that presumably is very favourably looked upon by a regulator, is something should happen in the future in terms of mitigating liability.
Well, in terms of, that's right. In terms of the Bribery Act, if you have adequate procedures in place, that can be a defence to the Section 7 offence, which is where you have a liability, strict liability for actions of others on your behalf. And if you can show that you have the policies and the procedures, the adequate procedures in place, then that can be a complete defence to that offence. So these are absolutely important to understand. But it also gives you a sense of the flavour of the organisation from its cultural perspective. All regulators talk about culture. Everyone talks about culture nowadays. It's an important watchword worldwide. But how do you identify and test that culture? Well, you look, or to my mind, you start with the tone from the top. What is the board engagement in all of these issues? Are the policies signed off by the board? And if so, how can you establish that? Does it say it on the policy itself? And if so, if they did sign off on it, did they properly debate it? Are there any minutes talking about them doing exactly that? What management information is created and is considered by the board, and does it address all of the risks that we're talking about? Is there a whistleblowing hotline? And if so, what is reported on that whistleblowing hotline? All the people listening to this who have whistleblowing hotlines within their organizations may well consider that whistleblowing hotlines are set up for disgruntled employees to moan about the business. That seems to be what a lot of whistleblowing hotlines are used for. But the reality is that you have a whistleblowing hotline as a litmus test as to whether there are any problems within the business. Is there an internal audit function? And if so, have they produced any reports in relation to matters? Third parties, we've spoken about, several of us have spoken about third parties. One of the greatest areas of risk in my area of practice. Is there a list of third parties? Has a geographical assessment of those been taken? Have they been properly looked at from a due diligence perspective? How sophisticated is the business in their use of those third parties? What sort of checks are conducted on them? Pensions is a big area which we haven't even touched on yet, but there's a new act in the UK, the Pension Schemes Act, which came into force last year. An understanding from a regulatory risk perspective would be to start to deal with the trustees early on and understand what the pensions risks are, because there are new criminal offences which have come out of that. And all the time within the due diligence area, you can make life easier for yourself from a regulatory perspective by having a standard list of questions which you can trot out in every M&A context. And obviously, we all have them within Stephenson Harwood. And these things can help you to focus on these areas early and therefore understand and, if possible, address the risks, or indeed walk away if the risks are too great. One of the things I've always said from a risk-sensitive basis to clients when they say, do we want to do all of this due diligence? I've said, well, if you're buying the company for 100 million and there's a 50 million fine from the Serious Fraud Office down the road, that's a 50 million company, not 100 million. And that tends to focus the mind a bit.
Well, absolutely. I mean, the regulatory fines can be huge, can't they? I mean, one thing I find, particularly as an M&A lawyer, is that we'll get DD folders full of policies, but the difference between, I guess, lip service in that we went to a law firm or a compliance consultant once upon a time, and actually instituting that sort of cultural compliance is quite stark at times. And so, it really does seem to be something that you need to be able to show that you are following through on, even if you have the documentation in place.
I think that's right. In my experience, it's not just the first round of questions, it's the second round of questions that focus in on the answers. That's the thing that will start to get you results in terms of due diligence, because that's when you start to go beyond the stock answers that they've got ready, and you start to understand what the business is all about from a regulatory perspective, at least.
Okay. One of the things I think you touched on earlier and is the increase in shareholder activism recently. And Genevieve, if I could bring you in at this point, it's an area that we're seeing increasingly. I know you and I have discussed in the past, and we're also seeing, all manner of certainly from in my part of the world in the last few years, we've seen Abraj and NMC, we've seen Wirecard, out in Germany, we're seeing all sorts of major sort of collapses whereby there appear to have been serious regulatory and perhaps even failings at audit level. I was wondering if we might sort of end up by discussing how those are feeding through.
Sure. You're right. I mean, I think one of the factors you need to bear in mind in this context is the fact that third-party litigation funding has become a really big business over the past 15 years or so. There are a lot of funders out there. There's a significant amount of investment to be made in litigation, and funders tend to like shareholder claims. And so I think we've been seeing a lot more growth in this area recently than hitherto, partly because of the availability of funding. There are claims that are being brought now that might not otherwise have been brought 10 years ago. Also, there's a growth in collective actions as well, partly because of the introduction of the opt-out mechanism in the Consumer Rights Act for competition claims. So, I mean, recently there have been a number of shareholder claims that have been brought under sections 90 and 90A of the Financial Services and Markets Act. Those arose from allegations that the company in question, in which the claimant shareholders invested, made untrue or misleading statements or omissions in its public information, upon which the claimants relied when making their investments. The argument being that if those statements had not been made, they would have invested their money elsewhere and would have made more money. So it's a loss of profits claim. But these include the Lloyds HBOS litigation, the RBS rights issue litigation, and the Tesco litigation. All of those claims involve third-party litigation funders, which just demonstrates how useful those resources are to shareholders who want to seek redress in the context of untrue public statements. It's important, I think, also to bear in mind that in that context, there's an awful lot of focus now on not only on accounting statements. In the case of Tesco, the alleged true or misleading statements were made in relation to its public accounts. But there's also a lot of scrutiny on companies in relation to, in particular, ESG obligations, which is a very big growth area. And indeed, there are a lot of not-for-profit organisations out there that are funded by philanthropists and other individuals and entities who are looking for the ability to hold companies to account for not having made true statements in relation to their ESG obligations and what they're doing, particularly environmental undertakings. And so, companies do need to be very aware of this and make sure that everything that they are putting out there into the public arena is absolutely true and has been DD'd, as someone else earlier mentioned. There's also been...
Presumably, sorry, this availability of funding means that many things which in the past you might have been able to get away with, or that just wouldn't have come back to bite you, are now very much back in play.
Absolutely, that, and the fact that obviously regulators are placing greater responsibility on companies, so that there's a greater regulatory obligation on companies as well as greater access to funding for private enforcement and other tortious claims. So, I mean, I'm absolutely sure that the recent cases, which are extreme, they're very, very big, multi-million, sometimes billion-pound cases, and using an awful lot of legal resource and court resource. I'm sure that will increase in the next few years. I should also mention there's also been an increased level of shareholder activism in the context of bids, with court challenges to schemes of arrangement by activists seeking improved valuations, which sort of mirrors the general trend towards shareholder activism in public companies. And it represents a new mechanism by which shareholders have sought to maximise shareholder value and scrutinise board decision making through the courts.
And is this a trend that you've seen sort of may have started in the US that we've sort of imported more into the UK, or is it sort of homegrown, as it were?
Well, obviously in the US, law firms invest themselves in litigation. So the availability of funding for these for all types of claims has been there for some while longer. It's a far more litigious environment. I wouldn't say that this is reflecting that this has been imported from the US. I think generally speaking, the courts are very, very cautious to open any floodgates. And so what you're seeing is a general case-by-case creep, where the statutory and regulatory provisions that are being relied upon, like the FSMA regulations, the CRA regulations, that those provisions are being used and explored by the courts, and there's a general but very gradual opening up of the ability to bring these claims. But I certainly don't think that it mirrors what's happening in the US.
Okay. All right. Fabulous. Well, I think that more or less brings us to the end of our time. So I just wanted to thank you all for joining. I believe the recording is available if you or your contacts may want to see it. Next week, we have a panel on distressed M&A on the 14th of June. So please do sign up for that. I think it just remains for me to thank our panelists for their time and preparation. Thank you for joining, and I hope you find that helpful and informative. Thank you.
Everyone.
Thank you very much.
Bye-bye.